A History of Legal Non-Conforming Short-Term Rentals in Victoria. Building capacity for visitor accommodation in Victoria's urban core was a key theme of the City 2012 Official Community Plan. The urban core consists of several designations, including historic, business, and residential. The community plan set economic guidelines to encourage tourism services throughout the urban core, including provisions to enhance visitor accommodation options. These plans were supported by bylaws enabling transient accommodations and included provisions to invest in the heritage character of the downtown through incentives for rehabilitation. Heritage restorations included buildings such as the Janyan, the Union, Lam Sam and Lee Chong, the Oriental, and Morley Soda Factory. To meet the growing visitor needs in Victoria, heritage restorations and new builds, like 613 Herald Street, were purpose-built to suit the needs of transient accommodations, many under 500 square feet and without storage or parking. To attract investment by short-term accommodation providers, these properties benefited from transient accommodation zoning, which enabled buyers to secure mortgages despite restrictive banking policies for micro-condos. Through the combined efforts of local short-term accommodation providers, the city's plan to revitalize the urban core and become a world-renowned tourist destination was a resounding success. To mitigate potential effects on the housing market, the city passed a bylaw to limit short-term rentals to principal resident units in 2018. However, the BC Supreme Court ruled the bylaw would not apply to 24 purpose-built or purpose-bought buildings in the urban core and would allow them to continue as vacation rentals under Section 528 of the Local Government Act. These properties would continue under non-conforming use status. In theory, this represented a compromise with a balanced outcome that retained the vibrant urban core community of 24 legal non-conforming buildings. Of the 1,600 units in these buildings, 634 were dedicated short-term rentals, and the remainder were long-term rentals or owner-occupied condos. However, despite the intention of the 2018 bylaw, the illegal short-term rental market continued to proliferate. By July 2023, there were more illegal STRs in the city than licensed ones. This trend was apparent throughout BC, and in an effort to mitigate the situation, the BC government passed the Short-Term Rentals Accommodation Act in October 2023. The bill provides both levels of government with stronger enforcement and oversight, including requiring hosts to register, data sharing by platforms like Airbnb, and limiting short-term rentals to principal residences, as Victoria had done in 2018. In theory, Bill 35 supports Victoria with much-needed resources to mitigate the impacts of illegal short-term rentals throughout the city, and, ideally, return housing stock to the long-term rental market. According to Minister Ravi Kahlon, one small section of the bill, Section 36, was included under a request by the City of Victoria. In reality, Section 36 rescinds the legal non-conforming property rights of the purpose-built and purpose-bought units in the city's urban core, threatening Victoria's vibrant tourism industry and financially debilitating hundreds of hardworking residents.